Good afternoon, ladies and gentlemen, and welcome back. Now we'll begin the last session of the conference, Session 6 on Advisory Proceedings. Judge James Luda Kateka from the International Tribunal for the Law of the Sea will moderate this session. Judge Kateka, please take the floor.
Thank you. Dear participants, the sixth and last session, I hope not least session, is on advisory proceedings. We have two speakers and two discussants. The first speaker is Professor Donald Rothwell of the Australian National University. He will speak on advisory proceedings and the law of the sea, past, present, and future. The second speaker is Professor Nilufer Oral, who is the director of the Center for International Law at the National University of Singapore, and she is also a member of the UN International Law Commission. She will make reflections on the role, on the role of advisory opinions for advancing UNCLOS, the case of the request for an advisory opinion submitted by the Sub-Regional Fisheries Commission. The first discussant is Professor Michael Becker of Trinity College, Dublin University, who is a professor of international law and human rights law. The second discussant is Professor Jin Yun Choi of the Law School of Jeju National University. So without much ado, I'll give the floor to Professor Rothwell.
Your Excellencies, fellow participants, commentators, and distinguished participants, can I extend my thanks to the organisers for the invitation for me to attend this important conference. It's been an absolute delight, I'm sure, with my Australian colleague, Professor Guilfoyle, to actually physically leave Australia after a long period of time of not being able to do so and to reconnect with colleagues. If I may, I wanted to pay a particular acknowledgement to Judge Paik. Judge Paik and I have a connection which goes back to the judge visiting the University of Sydney in the very early 1990s as a result of a conference that Judge, then Professor James Crawford, organised at Sydney Law School on the law of the sea. It was terrific to make Professor Paik's acquaintance at the time, and it's been wonderful to continue that association and to see Judge Paik here with us today, and indeed on a number of other occasions when I've been able to visit Korea in recent years. The presentation that I have for you today at one level is fairly basic, but it's intended to set out the structure, set out a framework for our consideration of the issue of advisory opinions and the law of the sea, and to really pave the way for my colleagues in terms of their substantive presentations, and hopefully will allow for some discussion amongst the four of us, but also elicit some questions from you. I must admit to some trepidation about engaging in this topic, especially given that there was a lot of reference to advisory opinions in our opening session on Tuesday, and indeed there's been continuing reference to advisory opinions. So I'm going to assume that there's quite a bit of interest in this particular topic. So you can see there my structure, and I really want to begin with an introductory consideration of the role of advisory opinions more generally in international law, particularly focusing on the International Court of Justice, and then transition to a consideration of the role of the International Tribunal for the Law of the Sea. So, to begin with, we're all familiar with the background and the history with respect to advisory opinions before the Permanent Court of International Justice and the International Court of Justice itself. And if you do the math, you're looking at something like 54 advisory opinions being delivered by the Permanent Court of International Justice and the International Court of Justice over a period of nearly 100 years. And of course, there is a very active debate at the moment within the United Nations as to whether or not there will be a fresh request for an advisory opinion that may come before the United Nations General Assembly in the next few weeks on matters associated with Palestine. In turning to look at this question, I was struck by the fact that it's difficult to really identify the real significance and the real impact and the real contribution that advisory opinions of the PCIJ or the ICJ have had to the law of the sea. Certainly in the case of the Permanent Court of International Justice, it didn't have the opportunity to engage in the modern developments in the law of the sea that we associate with events post-1945. So perhaps that's not so extraordinary when we think about the PCIJ's role in terms of advisory opinions and the law of the sea. When we move to the International Court of Justice, we have much more modern familiarity with the practices and procedures and the issues that arise in terms of ICJ advisory opinions. And if we think about some of the recent advisory opinions, some of those have clearly raised significant issues of legal and political controversies, certainly as reflected in the submissions made by states, on a number of occasions urging the court not to exercise its jurisdiction to deliver an advisory opinion on certain matters. And the Palestinian War case and the Chagos Archipelago case would be seen as examples of that. If I just try to focus on some ICJ advisory opinions that have had something of a maritime dimension, obviously the Chagos Archipelago case has very significant maritime dimensions, and Professor Guilfoyle reminded us about some aspects of those yesterday. But it's really striking, if you read that advisory opinion, how little reference at all is made to certainly the 1982 UN Convention on the Law of the Sea or to the law of the sea more generally. And I think it could be said that ultimately the advisory opinion really avoids engaging in law of the sea issues. That's perhaps not surprising given the nature of the questions that were being asked of the International Court. And that can be contrasted with the way in which ICLS is considering, or has been in the process of considering, the Mauritius Maldives case. There's also an historical example of an advisory opinion in which the ICJ looked at the constitution of the Maritime Safety Committee of the IMO. That has, of course, evolved into a really significant committee in terms of a whole range of issues with respect to the law of the sea, but ultimately that advisory opinion didn't directly engage in contemporary issues of the law of the sea. So, as a general proposition, this quick survey of the significance of advisory opinions to date principally within the realm of the PCIJ and the International Court of Justice, is that they've had marginal implications for oceans, the law of the sea, and oceans governance, I would suggest to you. However, consistent with the opening remarks made by President Hoffman on Tuesday, that may well be about to change. So it seems appropriate then to turn to think directly about the role and capacity for advisory opinions under the 82 Convention, and in particular the role of the International Tribunal for the Law of the Sea. One of the things that's curious when you look at the Convention, and Part 15 in particular, that we've given a lot of attention to over the last few days, is that there's no general advisory opinion competence under Part 15, to be contrasted with the statute of the International Court of Justice. And indeed, Part 15, as we know, is headed Settlement of Disputes, and that raises an obvious question as to whether or not an advisory opinion relates to matters associated with disputes. Now, the clear exception is Article 191, where we see direct reference to advisory opinions. Article 191, though, is not found in Part 15 of the Convention, it's found in Part 11. It's interestingly the last article in Part 11 of the Convention, but it is found in Section 5 of Part 11, dealing with the settlement of disputes and advisory opinions. So, quite naturally, from the perspective of looking at advisory opinions and the International Tribunal for the Law of the Sea, there's been a lot of attention and focus on these issues. And just breaking down Article 191, I would suggest to you that these are some of the core elements associated with it. In that regard, particularly think about the aspect that an advisory opinion can be requested of the Seabeds Disputes Tribunal under the Article 191 process by the Assembly of the International Seabed Authority or the Council of the International Seabed Authority, consistent with Article 15910. And the wording in Article 15910 is interesting because it refers to on any matter within the remit of the Assembly or the Council. It doesn't say on any legal matter, it says on any matter. But nevertheless, Article 191 arguably qualifies that in terms of the matter being one that relates to a legal question. The other interesting aspect of Article 191 is the fact that it uses the word urgency, that the opinion shall be given as a matter of urgency. And we had some interesting discussions about that in terms of urgent procedures subject to temporal and time limitations in the context of provisional measures orders yesterday. And if we think about the way in which the Seabed Disputes Tribunal Chamber, I should say, looked at the application that it received from the Seabed Authority in 2010, that application was made on the 11th of May 2010. Oral proceedings occurred before the Chamber in September 2010, and the advisory opinion was issued on 11 February 2011. So in terms of issues of urgency, that suggests that there was, over a 9-month period, a fairly clear attention, dedication and focus by the Seabed Disputes Tribunal in actually giving that advisory opinion. If we look into the additional mechanisms associated with advisory opinions, we can look to obviously the statute of the tribunal. Annex 6 gives us a range of details with respect to the organisation, not only of ICLS, the competence and procedure. It talks in particular about the role of the seabed disputes chamber in terms of giving advisory opinions. Those practices and procedures reaffirm, and this has been a matter of controversy, and it's reflected certainly in some of the literature that's emerged on these issues, that ICLS and the chamber has and can exercise the rule of competence, and that's reflected in Article 288, Para 4 of the Convention. Now, that doesn't mean to say that the states who are parties to the Convention may raise objections, may raise concerns, may raise legal arguments as to whether or not the tribunal should seek to deliver an advisory opinion, and indeed the practice is that that has occurred, but ultimately these are matters for decision by the tribunal or for the relevant chamber. This then goes to the rules of the tribunal, which of course have been framed during the lifetime of the tribunal, and the most significant aspects of that can be found in Article 138 of the tribunal's rules, which open up additional sets of mechanisms for advisory opinions in addition to the procedures that I've already spoken about that exist under Article 191 of the Convention. I'm not going to talk in any detail about the advisory opinion that was delivered in the fisheries matter. I will just make some brief reference to the Seabed Disputes Chamber Advisory Opinion from 2011. You can see there on the slide the request that was formally made to the Seabed Disputes Chamber. It references the relevant articles and rules that I've been referring to. And then in terms of the actual opinion itself, the opinion is notable because the view of the chamber was that unanimously they had jurisdiction, unanimously they responded to the questions that were asked of them, and they answered the three questions unanimously. And in doing so, that raised a range of issues with respect to jurisdiction, admissibility, and the applicable rules. And so for the first time, we saw the Seabed Disputes Chamber focus and unpack some of the aspects of the practice and procedure that certainly that chamber would apply in terms of advisory opinions. So, moving through this and coming really to the core issues that I wanted to discuss with you on this issue. What can we say in terms of what can be learned from the Law of the Sea Convention and advisory opinions, moving from an analysis of what I've just covered? The first is that unambiguously, the Seabed Disputes Chamber does have an advisory opinion capacity, and that jurisdiction extends to matters that fall within the remit of Part 11 of the Convention. And we've already heard Judge Paik give some indication as to the type of role that the Seabed Disputes Chamber may well play as we see activities within the International Seabed Authority and within the area continue to develop in coming years. To that end, what can we learn from the interpretation of the Law of the Sea Convention? Well, we only have one advisory opinion on those procedures to date, but I think we can say from that that the Seabed Disputes Chamber, subject of course to the composition of the chamber but changing over time, is clearly willing and able and wishing to engage constructively in the processes that it sees that it has in terms of dealing with some of these questions. What is the significance of an advisory opinion for ICLS? Well, it certainly extends the role and the scope of the tribunal, I would suggest to you. And in that regard, it gives a level of distinction to the role of ICLS. We've spent a bit of time during this conference talking about the role of various international courts and tribunals under the Law of the Sea Convention with respect to dispute settlement. But this is a very distinctive role that the tribunal has. And yes, of course, the ICJ can still deliver advisory opinions on matters associated with the law of the sea, but certainly the role and capacity of the Seabed Disputes Chamber is truly unique within the Law of the Sea Convention framework, and arguably the way in which the tribunal can exercise its general advisory capacity under Article 138 gives to it additional capacity. So I want to move then to trying to unpack some of these questions that I've shared with my fellow colleagues on the panel, especially the commentators, and try to answer some of these issues. So what are the possible options moving forward with respect to advisory opinions under the frameworks that I've been discussing? Well, theoretically, they could really be endless. And we can anticipate that certainly with respect to issues arising under Part 11 of the Convention and the role of the International Seabed Authority, that there is a great potential for questions and issues to evolve over a period of time. And I've already alluded to the fact that Judge Paik has referenced that in his opening conference keynote. With respect to Article 138 procedures, that could also extend into multiple different areas. So in that respect, the issue areas and topics could be vast and subject to evolution over time as the Convention develops and as maritime and legal issues associated with the sea continue to develop. So once again, being parochial and picking up on observations that my good friend and colleague, Professor Guilfoyle, raised, where he referenced yesterday the role of small island states. Can we think of circumstances where small island states would seek to utilise in creative ways some of the procedures and mechanisms consistent with Article 138 rules? And already, if we think about the Chagos advisory opinion, if we think about the ability of small states to win support in the United Nations General Assembly for requests for advisory opinions, we can say that there's a track record of small states being able to advance politically and gain support for advisory opinions, certainly in the International Court of Justice. At the risk of being very hypothetical, let's consider this scenario. We all know that within this region and globally, but particularly within this region, one of the more contested issues is the navigational rights and freedoms of warships. And various states take a range of views on that. Is there a possible scenario in which we could foresee an advisory opinion being sought on that issue? Is it an advisory opinion that could be sought by NATO, for example? Is it one that Australia and the United States could seek under the framework of the ANZUS Security Treaty? Could it be sought by Australia, India, Japan and the United States under the so-called Quad framework? Or could it even be sought by ASEAN states? Now, immediately an issue might arise as to whether or not those institutions, those frameworks, have the capacity to actually seek advisory opinions. Of course, they could seek to amend their charters or statutes, or they could enter into an agreement conferring authority to seek an advisory opinion on that issue. So there's some hypotheticals that we could think about, but that's certainly quite a contested issue which some states, I think, would benefit from gaining some certainty on. What issues could arise following a request for an advisory opinion? Well, I think that we can immediately identify issues of jurisdiction and admissibility, and I think much will depend upon where the request is going to in terms of whether it's to the Seabed Disputes Chamber arising under the Article 191 process, or if this is a ICLS Rules of Procedure Article 138 application. So the variables are really considerable here. One important point to note is one that I've already observed, and that is that Article 191 expects a level of urgency in terms of the way in which the advisory opinion would be dealt with by the Seabed Disputes Chamber. Third question. Well, this could really be quite important for the development of the Law of the Sea Convention. Much, of course, depends upon the timing. Much, of course, will depend upon the dynamics at the time, and much will depend upon why there's a momentum behind an advisory opinion being sought to bring some certainty and clarity to the legal issue on which the advisory opinion has been sought. Nevertheless, there could be a question as to whether or not the question that's being asked of, we'll take the tribunal, is one that's sufficiently meritorious, sufficiently worthy, sufficiently substantive to really engage the time and the effort and the energy of the tribunal, or whether it perhaps is a more marginal issue that could be resolved through other appropriate mechanisms. That fourth question, I think, reflects that on the basis of everything that we're hearing in the public domain, and I'm just a humble international legal scholar who closely follows some of these things, but I'm not in New York or Washington or other places of prominence in terms of where these debates occur. I think we'd have to say that yes, there is gathering momentum. States, non-governmental organisations, international civil society are increasingly looking at options to try to bring about some clarity and resolution on some of these issues, and I'm sure that we'll hear a little bit more from other members of this panel on these issues. Fifth question. If we see ICLS or the Seabed Disputes Chamber hesitate or not being quite as open to delivering advisory opinions, is there some possibility that a pivot will occur and states will instead go to the tried and tested method of the International Court of Justice? Well, we need to accept that there are significant political and procedural issues that arise with respect to any ICJ advisory opinion to take place. There's also a temporal element which may not make the International Court of Justice quite as attractive as opposed to perhaps more speedier or more efficient options for advisory opinions under the Law of the Sea Convention frameworks that we've been discussing. We also need to recall that there have been 4 ICJ advisory opinions throughout the 2000s, with another possibly to be made. So we clearly know that the ICJ has the ability to exercise advisory opinions, but whether it might be seen as the best alternative to some of these processes, I think really remains in the lap of the states. And could we see a situation where the International Court of Justice possibly competes with the Part 15 ICLS Seabed Disputes Chamber mechanisms for advisory opinions? Well, quite possibly that may well be the case, and we know that strategic litigation in various states and those who are interested in supporting those states, members of civil society, are constantly looking for options to litigate, ventilate and seek resolution on some critical issues in the law of the sea. That may not necessarily be such a bad thing, but that brings us back to concerns that we've had a little bit of a discussion about in this conference about possible fragmentation of international law. Colleagues, I want to close by saying that if we reflect upon the theme for this conference, Law of the Sea for the Next Generation, to a degree, that's what advisory opinions are about. Advisory opinions will provide the future generation of Law of the Sea practitioners, scholars, diplomats, with guidelines, roadmaps in terms of some of the critical issues that we know exist in the law of the sea. And that clearly is important in terms of what an advisory opinion can achieve. Nevertheless, I have to end with a note of caution. I have been, and I'm sure many of you have been, very troubled by the events of 2022, with references being made to the possible use by one state of nuclear weapons. And yet we have an advisory opinion dealing with that issue, which unfortunately did not bring about a completely clear resolution on the question of the use and possession of nuclear weapons. So we need to be careful for what we wish for. Thank you.